It's one of the riskiest and rarest gambles in any criminal proceeding. A defendant taking the stand to testify in his or her own trial. On the one hand, it does offer a chance for the jury to hear from the accused directly in their own words. On the other, it gives the prosecution an opening to hammer away and potentially sway the jury in the prosecution's favor right then and there. It's a testimony that can make or break a case. We saw it with Kyle Rittenhouse's trial. The jury there, done with deliberations for the day. More on the telling questions that jury asked the judge in just a moment. We also saw a defendant take the stand today in another high-profile trial, the killing of Ahmaud Arbery. He's the black man who was shot and killed last year while he was just jogging near his home outside Brunswick, Georgia. Today, defendant Travis McMichael broke down as he talked about the moments right before he shot Arbery 3 times and killed him.
What did you do?
I shot.
Why?
He had my gun. He struck me. It was obvious that he was. It was obvious that he was attacking me. That if he would have got the shotgun from me, then it was this is a life or death situation, and I'm going to have to stop him from doing this. So I shot.
Virtually the same defense as Rittenhouse's, that he fired the gun in self-defense as the victim was attacking him, going for his gun, that there was nothing else he could do. His father, Greg McMichael, and his neighbor, William Bryant, are also on trial. No indication yet whether they'll also take the stand as the defense continues its case. Legal analysis now. David Henderson, civil rights attorney and CNBC contributor, who's currently having a musical interlude. David, did McMichael help himself on the stand today?
You know, Shep, he did. And this is a case where, is it always dangerous to put your client on the stand? Absolutely. But in this situation, you have to. Because you have to understand, he's not saying I didn't do it. He's saying I was justified in doing it. And so you have to offer some evidence to support that justification. Here's citizen's arrest and self-defense. Not saying I agree, just saying there has to be some evidence. And with these facts, I don't know what you would have without his testimony.
If you were representing these defendants, would you recommend the other two also take the stand?
You know, that's very difficult to say. I'm going to have to see how the evidence develops in order to make that determination. And generally, that's what goes into these types of decisions. You want to see how well he holds up on cross-examination. If the prosecutor scores a bunch of points, then it's very risky putting them up on the stand, and you don't want to unless you've just lost too much ground. But if he holds up under cross-examination, it'd be hard to get me to put the other two on the stand, though. With Attorney Goff, it's always hard to anticipate exactly what he's going to do.
You know, we've seen 2 high-profile defendants get emotional while testifying. First, Kyle Rittenhouse, and now Travis McMichael. How impactful can that emotion from a defendant be to a jury?
Shep, it always depends on the person who's on the stand and on the way they've been prepared to take the stand. And you have to give it to the attorneys representing the McMichaels. They're effective trial lawyers. I thought he was prepared to take the stand much more effectively than Kyle Rittenhouse was, even though I thought Kyle Rittenhouse was well prepared. And I thought that his tears in the context of the rest of his testimony is dangerous because some people might find it persuasive.